Here, Mark Rumold is with us. He is a staff attorney with the Electronic Frontier Foundation, EFF.org. Mark, welcome back to the program.
Hi, thanks for having me.
The EFF, I read this story was it yesterday, the day before? Wednesday, that you guys have been fighting for a couple of years, almost 2 years, to get the federal government to, well, actually, let me let you tell the story instead of me telling the story. Tell me about this recent court case.
Sure. So on Wednesday, the government finally released, after what you said, a somewhat prolonged court battle, an opinion of the FISA, the Foreign Intelligence Surveillance Court, that held that some of the surveillance the NSA was doing was unconstitutional and had violated the FISA Amendments Act, the very broad and permissive law that the NSA uses to conduct a lot of its surveillance. But the story behind the release of the opinion goes back, over a year. It goes back to the summer of 2012 when the FISA Amendments Act was up for reauthorization. Senator Wyden pressed the Director of National Intelligence to declassify the fact that this court opinion existed.
Was that Mr. Clapper at that time?
Senator Wyden, it was secret from the public that a court had declared this surveillance to be unconstitutional.
So was that Mr. Clapper at that time?
Yes, it was Clapper.
Okay, so Ron Wyden is asking Clapper, was there a court decision on this? Are you guys violating a court order? Is that basically what he was?
Well, so Senator Wyden was briefed on it. Senator Wyden knew, but what Senator Wyden wanted to do was make the public aware that this court order existed. So he wrote a classified letter to the Director of National Intelligence. We still haven't seen that letter. That I assume, pressed the DNI to make public the fact that this opinion existed, so that the public could use that information in intelligently debating whether or not the FISA Amendments Act should be reauthorized. Right,
and that court decision in plain English said?
In plain English, it said that some of the surveillance that the NSA was conducting violated the Constitution, and it violated the FISA Amendments Act.
Did it order the NSA, therefore, to stop it?
It gave the NSA the option. It gave the NSA the option of immediately remedying the problems that the court had identified, or stopping the program.
Right. So it's sort of like, somebody gets arrested in the act of shoplifting, and the police officer says, you can set that item back down, sir, and I'll let you go, and we'll pretend this never happened. Is that kind of thing?
My sense from reading the opinion is that the court was frustrated. The court was frustrated that the NSA had been representing one thing to it for the past 3 years, when in reality the NSA was doing something entirely different. Okay. It seemed like the court had been misled in the past, and it was upset about it.
And in fact, my
sense from the opinion is the court wanted to take advantage of the fact that the NSA was forthcoming this one time, and pressing them to make changes to their program, but there was certainly a palpable frustration.
Right. So this was 2011, right?
Yeah.
And so the NSA had been spying on us in a way that was illegal and unconstitutional since, wasn't it from 2008?
Right, 2008.
Okay, from 2008 till 2011. And so that would be the end of the Bush administration, right up until 2011. And the FISA court didn't even know about it. And when they found out about it, they said, stop, and please stop. Right. And Ron Wyden knew that this had, and this all happened in secret, behind closed doors, and nobody in America knew about this who didn't have a security clearance and the specific information. Senator Wyden did know about it, and so he gets Greg Clapper in public and says to him, was there a court decision like this? And Greg Clapper says what?
Well, no, it didn't happen like that.
Okay.
Like I was saying, Senator Wyden sent a classified letter to Clapper to push him to declassify the fact that this opinion existed, and eventually DNI relented and made public the fact that it existed.
Okay, and then so the basis of your lawsuit was what?
The basis of our lawsuit, so after DNI declassified the fact that the opinion existed, we put in a FOIA request for the opinion.
The Freedom of Information Act request.
Yeah, Freedom of Information Act request. One of the kind of basic tenets of classification is that you can't classify information to conceal illegal conduct. So we were pretty confident that the government would have to turn over parts of the opinion to us, at least parts, if not large.
Since their conduct had been classified as illegal by that opinion.
Right,
Okay.
exactly. It was an opinion that specifically dealt with unconstitutional and illegal behavior. So we were confident that we'd get part of it. We put in the request. The government never responded. So we filed suit 30 days later. During, probably the next 4 months, while the FISA Amendments Act reauthorization debate was going on, the government continued to drag their heels. They continued to refuse to disclose the opinion, even though at that moment, that's when the opinion would have been most crucial to the debate on whether or not the law should be reauthorized.
So really what they were trying to do was not so much prevent you from knowing, but prevent you from informing the members of Congress who didn't have the security clearance at the level of Ron Wyden, but who were debating whether or not to reauthorize this thing, to prevent them from knowing that this thing that they wanted reauthorized had already been declared illegal.
Sure. So both informing Congress and informing the general public, right? What's pretty startling is so the FISA Amendments Act ended up being reauthorized on December 30th. 4 or 5 days later, I think, January 4th, 2013, the government finally released records to us, and they were almost entirely redacted. So the whole
blacked
time
out, redacted, fancy word for blacked out. You couldn't read it.
There was nothing.
Yeah. Okay.
The entire time they were refusing to give us this information so we could use it to contribute to the debate. Once the debate was over, they felt it was the coast was clear. They could release these documents, and they basically released nothing to us. So from that point, we continued the litigation, and the government came back, and their primary justification for withholding the opinion was that the Foreign Intelligence Surveillance Court itself was preventing them from disclosing it. And so we said, that's a crazy argument. We're going to go ask the FISC, and the FISC came back, and I came on your show previously to talk about this aspect of the case. The FISC rejected the government's argument and said, no, we're not preventing you. It's you, executive branch. That's the only government body obstructing this information from being made public.
Mark, we have a little less than a minute left. So where do we stand now, and what can people do, and what are you guys doing over at EFF.org?
Well, we're continuing to fight in the courts and in the court of public opinion to try and rein in the NSA's spying. We're pushing very hard for a congressional investigation that really looks at the full scope of the NSA's spying programs.
Right.
And
we need a new church commission.
Yeah, exactly.
Yeah. And do you have a champion for that? Anybody in Congress?
Ron Wyden has been a leading voice in this the entire time. We'd love to see him take part in it, and both sides of Congress are really starting to agree that something needs to be done.
Well, good on you, Mark Rumold, with the electronic staff attorney for the Electronic Frontier Foundation, EFF.org. Get over there, check it out, read the stories, toss some support their way. Mark, thanks for being with us today.
Thanks so much, Tom.